dream. I was flying high, I was feeling fine. I won't be put in line, 'cause I'm ready to do my time.
Simply Financial with Christopher Calandra, Certified Financial Planner, is an innovative, comprehensive, informative, and cutting-edge podcast that discusses financial topics ranging from personal finance, economics, politics, and personal growth. Simply Financial will cover intriguing and thought-provoking questions so that the listener can simply increase their financial IQ.
Hello, I'm your host, Christopher Calandra, for this week's episode of the Simply Financial Podcast. This is episode number 29 of Season 3.
Backed by popular demand, the expert interview series featuring Mike Giardina, estate planner, is re-airing this week.
Today's episode, I have a guest with me. It is Mike Giardina, a partner and attorney at Henry and Federer. He specializes in estate planning and elder care. He and I have worked together recently on a pretty complex situation, and I have been talking a lot with my clients about estate planning, making sure you have a will, your beneficiaries in order, things like that. So I thought it would be great to have Mike in. So thank you for joining me.
Thank you for having me.
Should I have said Michael Giardina and been more formal?
No, whatever you want to call me is fine.
All right, no problem. So what I wanted to talk a little bit about is, let's assume that most people, especially individuals that are 50 and older, let's just assume for a moment that they have some type of estate plan, will. When is it a good time to review your estate plan? That's kind of one I wanted to cover with you. So before we do that, I probably screwed it up already. But before we do that, everybody should have a will. Agreed?
Anyone over 18 should, yes.
Anybody over 18. Even
Absolutely.
if they don't have a lot of assets, they may not be married, you should still, just as an adult, have one. Go see an attorney, or in a simplest situation, they could even go on LegalZoom.com or something like that. I'm sorry. Only if it's very simple.
Right.
And so you have a plan. Now, when should you update your will and estate plan?
I'm going to first jump off of something you said.
Okay.
Everyone should have a will at the age of 18. And the main reason for that is if you don't decide, then Connecticut state statute, or whatever state you're living in, will decide where your money goes when you die. So, which may not necessarily always be the way you want it to go. So it's very important to have a will.
So that's interesting. We were talking beforehand about our children who are not too far in age from one another. But my daughter's a little older than yours, but she turned 18 in August, and we don't have a will for her. So we should have a will for her.
To the extent she has assets, yes.
Okay.
Even if it's a small one, why not have the will?
Mm-hmm.
Again, if you're going to use LegalZoom, then it should be quick and inexpensive, and she should have something in place.
Okay. No, that's good. That's good.
I'll give you just a quick, for example. I had a person who passed away, a husband, didn't do a will. He had a wife and children, and he had some fairly sizable assets. And as a result, under Connecticut state law, those assets are going to get split equally between his wife and his children, as opposed to all going to the wife, which is presumably what he would have wanted.
So that's interesting, and we want to be clear because we have listeners all over the United States, and actually, I'll say this with a lot of pride, we have an increasing number of listeners that are even outside the United States, because I have clients that are traveling, and it's kind of a funny thing. But in Connecticut, what you're saying is if a married, let's say a married person, male, passes away, and there's no will, the state of Connecticut has a pecking order, priority on how assets will be dispersed. And in the Connecticut, half would go to the spouse and half would go to the children.
Yes, I mean, in simple terms. Yeah, it gets more complicated depending on whether there's children from a prior marriage or all the children are from this marriage. But
right.
Yes.
So that's one of the great reasons why it's so important to have a will, because in lots of instances, that is not what the family would have wanted, but they're going to have to bend to the will of Connecticut law, and other states might have different rules that maybe make sense or not make sense depending on the circumstances. But if you have a will, none of that matters, because that's your chance to tell your heirs and your family what you want to have happen with your money.
Correct. And just for sake of clarity, your will only will deal with your, what I like to call probate assets, as opposed to non-probate assets.
Okay, so listeners, probate assets, well, non-probate assets would typically be things that have beneficiary.
Correct.
So 401ks, IRAs, annuities, life insurance, stuff like that.
Correct.
Okay. So back to what I thought was going to be the starting point, but wasn't. So when should you review your estate plan? If nothing changes, but a certain number of years go by, should you have your will and accompanying documents updated?
Yeah, my general rule of thumb is every 3 to 5 years from when you've executed documents, they should be reviewed. That's just a benchmark. And then on top of that, whenever there's a change in family circumstances or dynamics, or something tragic happens, or something happy happens, someone dies, a baby's born, a grandchild's born, a divorce, anything life-changing or family-oriented, you should have your will and your documents checked to make sure it still complies with what your wishes are.
So I've run into this before where pick up a client, husband and wife, let's say, and then you start working on their planning, and you find out that the husband never changed the beneficiary, and it's his mom.
Or his sister.
That's always a fun conversation because that doesn't really work in most instances.
No.
Not looked on kindly. So married, divorce, separation, change in family structure, that would include, I imagine, if there's changes in health of even the beneficiaries, like a child passes away or a spouse passes away or things like that, right?
Absolutely. Any sort of family event, a child becomes disabled, God forbid, anything along those lines.
And how important is it if like I have a daughter, so perhaps someday she'll get married and perhaps she'll take her husband's name, and so would that mean updating things because she will adopt a new last name, or that's not really
not
that
something
important?
I would, if someone called me and said my daughter got married and I want to change it because her name's changed, I would probably say if that's the only change, well, I'd love to be able to charge you to do that, but it wouldn't make any sense.
All right. And what about instances where there's a significant change in someone's finances? They come into money or they become wealthy over time. Is that also?
Absolutely. So if there's an inheritance, and that usually falls within the guidelines of someone passes away like a parent. But if there's an inheritance or you hit the mega millions or something along those lines, you should definitely get your estate plan reviewed.
Okay. And why is it important in the case of a divorce? I don't know what the exact statistics are. We could look them up. But, lots of people, unfortunately, get divorced one time, in some instances, several times. So why is it important in that case when you have different family makeups than your traditional nuclear family? Can you speak to that?
Sure. If my client is the one who's getting divorced or remarried, and if there's children from that prior marriage, there's a whole conversation that needs to be had. So, for example, if I have a client who's on his or her second marriage and has children from a first marriage, the conversation is going to take a certain path. The first question is going to be, how much do you want to leave to your second spouse of your assets, and how do you want to do it? So in that situation, if I'm married and I'm leaving everything to my new spouse, if I leave that outright to her, there's no guarantee that she's going to then leave that money to my children. Mm-hmm. She can leave it to whomever she wants.
Okay.
So that's usually a somewhat awkward conversation to have.
And the strategy, I would imagine, is different when you have minor children in your scenario as opposed to adult age children.
Not necessarily.
No?
No, because either way, if I'm leaving my assets to my new spouse, where that money goes after she passes away is of concern to me.
Okay.
Or should be.
And what about if there's a change? We talked about a change in financial circumstances, but originally I was thinking, and I would imagine people listening to this would be thinking that it's a change of the person who is thinking about updating their estate plan. But what about if there's a change in the world of my beneficiaries? So a classic example, I have 2 children. What are some triggers that I want to think about updating my estate plan that involve what's going on in their lives?
So oftentimes, and I think I'm going to answer this question. If not, just stop me.
I'll let you know.
Certain times people will come in, we'll review their beneficiary designations with them, and predominantly it's usually a spouse, and then it's children. What I'd like to review with them is specifically to understand what their intentions are for that contingent beneficiary, being their kids. a lot of times people will name their children, and they don't realize that if one of their children should predecease them, all of it's going to pass to the survivor, not necessarily to the deceased child's children, if there are any. Okay. And they're essentially disinheriting grandchildren. Mm-hmm. So we have that conversation, which can take on a whole different...
Okay. And what about situations where the children might not be responsible with money? So the heirs of your client might not be responsible for money. It might be something that's bad behavior like drug abuse, or it might just be, youthful indiscretion kind of stuff. Mm-hmm. But is that something that should be addressed too when updating an estate plan?
Absolutely. That's one of the main reasons to do estate planning. Mm-hmm. That would involve a whole conversation as to, do we want to leave money outright to our children? In that situation, I would presume the answer would be no. So we'd have to update the beneficiary designations to make sure nothing passes to them directly. I would imagine in that situation we would create some sort of trust for them to protect them from themselves, from creditors and or predators, so that those funds are available for the children for their lifetime.
Okay.
In which case also the beneficiary designations would have to be coordinated with the estate plan.
And so there are things that you could do from the grave to control money in numerous different ways, right? There's techniques and trusts and all kinds of language that can be included to try and protect, quote unquote, the spendthrift from not making good use of the money.
Absolutely.
All right. That's where you come in?
Right. Yeah. There are generally three major reasons why we would want to create trust for children. One is because of their minorities. Mm-hmm. I shouldn't say that. They're minors.
Minors, yes. It's not that type of show, but yes.
They are spendthrifty. Money burns a hole in their pocket, or they have some sort of special needs, or they're on some sort of state program where they need to be protected.
And I saw in researching this, you do have a specialty with special needs planning.
I do.
So that for you and your firm is an area of concentration, right?
Yes, we concentrate in that.
And given that we live in Connecticut, and I talk a lot about this on the show with clients and whoever else will listen, it's unfortunate, but the reality is in the state of Connecticut, we have a lot of our citizens moving out of state.
Correct.
And I think less moving in state. But when somebody is moving out of state, how important is it to address their will and estate plan if they become a resident of another state? The most common example is Florida. How does that work?
Yeah, I always tell my clients when they are moving out to have their documents reviewed. Each state is fairly state-specific in terms of what their laws provide. So something that we draft in Connecticut, there might be some subtleties in Florida law or New York law or Carolina law that needs to have some inclusions or maybe things taking out of it to ensure that their assets are protected properly.
Is it too extreme to say, though, that it's possible that if you had a will that was good in Connecticut and you were a resident in Connecticut and then you become a resident of another state, that if you passed away you could not have an executable will? Could it be that extreme?
I can tell you in reverse, because I'm not licensed in all of the other states. But if someone comes to Connecticut with a will from another jurisdiction, that will be accepted here if it was valid in the state where it was signed.
Okay.
So the will would not
reciprocity?
be. I can only speak coming this way.
Okay.
Yeah, I don't know what other states do. I think most do have reciprocity in that situation. That a Connecticut executed will would be accepted in that state. But again, I'm not sure what each state has different tax laws too.
Right. And I think sometimes people that are not financial geeks like I am and the rest of my team here at Elliott Wealth, a lot of people think estate plan that they're picturing what you see in the movies where you have, a mega millionaire with mansions and a trophy bride and it's this largesse process. But when we say estate plan, it's not something that's necessarily super creative, technical, not necessarily lots of money or, real estate in foreign countries or anything like that. Estate plan can be as simple as a will, right?
Correct.
And what are some of the most common documents that accompany a will that are part of the estate planning? Like a power of attorney is one, right?
Very important document, yes.
So could you just briefly explain what a power of attorney does and why it's important?
Absolutely. Going back to what you said about being 18 and having a will, the way I refer to an estate plan is everyone should have what's called the Holy Trinity of documents: a will, power of appointment,